Here's a remedies problem that gives us a good look at the boundary between torts and contracts. Also, we observe that there's a four-part call of the question, which means this is going to be a more straightforward and probably a somewhat easier problem than the most difficult of them. Have a look with me at the call. It reads, Flywright seeks dismissal of Prof's complaint by a procedurally proper motion claiming 1. The 2-year statute of limitations for tort actions bars the suit. That's a pretty straightforward call of the question. We're going to have to look carefully at the dates and then make a decision. Certainly question 1 is a short answer question, not really an essay question. 2. The complaint fails to state a cause of action in tort. Here, what we will do is identify as many theories of liability as we can in torts and then rehearse the elements to figure out whether or not the defense allegation is true. Next, we turn to question 3. The complaint fails to state a cause of action in any other legal theory. Well, we've already referred to torts in question 2, so question 3 is inquiring about whether or not the plaintiff has a theory of liability arising out of any other subject, by which they almost certainly mean either contracts or real property. We turn to finally the call of the question number 4, which reads, even if the complaint states a cause of action, the damages sought cannot be recovered by any theory suggested by the facts alleged. Well, simple enough. We are being asked a straight damages question, which will require us to compare the damages available in tort with damages available under another theory, probably contracts at this point. And we know that in torts, the damages available include compensatory and punitive damages. In contracts cases, we are not interested in punitive damages, but compensatory damages becomes a little bit more complicated because there is the cover remedy and then beyond that, consequential damages. And as it turns out, this question is asking us about those consequential damages. Finally, the question asks, how should the court rule on each of the grounds used in support of the motion to dismiss? Discuss. So we've got a straightforward call. Let's go up and have a look at the facts, and we'll see they are quite straightforward also. In paragraph 1, we see that the professor buys a ticket on the last day of December 1984 for a trip that he is planning on taking on the 10th of January 1985. And we see that there is a $10,000 lecture fee at stake. At the end of paragraph 1, we see that the employee has prepared the ticket and issued the ticket to the plaintiff. So we will have a little issue of respondent superior in this analysis. Now, take a look at paragraph 2. In paragraph 2, we find out that this professor missed his flight, and we see that the principal reason for this is the ticket was wrong at the time he bought it. He ends up missing the flight, he misses his lecture, and he has to return the advance fee that he obtained for his speaking engagement. So we see him filing a lawsuit on January 5, 1987, more than 2 years after he bought his ticket, but less than 2 years from the date of his lecture. We see that he files suit, and look carefully at the last paragraph. We see that he is alleging negligence. That is his tort theory of liability. And as we look at it even more precisely, what we will see is what the specific tort theory of liability is negligent misrepresentation. That's just a special type of negligence that deals with facts similar to these. It would be okay to just call it negligence, but negligent misrepresentation is the more precise label for what happened. The elements remain the same: duty, breach, causation, damages, subject to defenses. Now, let's pause for a moment and put ourselves in the position of the professor. I have been a paid speaker for many years, and I can tell you that the number of inquiries and checkups that I make with the airline to make sure the flight is on time go up in direct proportion to how much money I'm getting paid to speak. So we look at the conduct of this professor, and clearly the defendant is going to have a contributory or comparative fault defense, because this guy just took the ticket broker's word for the time of the ticket. It's apparent he never checked never independently confirmed, and just showed up at the airport on the day of the flight expecting to be able easily to board. And just about anybody who flies for business purposes does a lot more due diligence than that before going to the airport. So we get back to the call of the question, which we've already reviewed. Turn the page and have a look at the outline of issues that I've prepared for this fact pattern. And here, what I want to do is reinforce and guide you through the way to think about these issues. So we examine the first call of the question, does the 2-year statute of limitations for tort actions bar this suit? The answer is probably not, although a fair argument can be made either way. The real issue is, when does the statute start running? I would suggest that the better answer and the more likely correct answer is that the statute begins to tick. The clock ticks at the moment the plaintiff discovered his injury. This plaintiff was not aware that there was anything wrong with the ticket at the time he bought it, although a case can be made that, in fact, the negligence of the defendant was complete at that time. Still, the plaintiff was unaware of that negligence until the date of his flight. And although that ignorance may be a justification for reducing the plaintiff's final award, it doesn't toll the statute of limitations. So the question presented, does the 2-year statute of limitations bar the action? Answer, probably not, because he learned of his injury on January 10, 1985. He files his action January 5, 1987. It seems apparent that the 2-year statute of limitations will not bar this action. Next, we turn to the second call of the question, which is the most elaborate and the most complicated one that we have to address. Again, our approach intellectually is spot the issue, break it up into elements, consider the elements. So, in order to establish a negligent misrepresentation, first we have to show that there was a misrepresentation. That's easy to do here because the workers at Flyrite had not updated the computer system. So they were working with old data at the time they made the representation to the plaintiff, and at the time they sold him the ticket, their data was wrong. And as a result, they materially misrepresented to the plaintiff the time of his flight. Also, we see that vicarious liability is at issue because we have an employee acting in the course and scope of employment and doing something careless that hurts the plaintiff. So once we've established those threshold issues, then we just go through duty, breach, causation, damages, and defenses. Now, let's examine duty for a moment. One idea that may occur to you is this. Could the plaintiff argue, that the defendant, Flyrite, owes a higher than ordinary standard of care as a result of its intimate connection to common carriers? Now, I would suggest the likely answer would be no, but still, thinking like plaintiff's lawyers, we want to establish the strongest claim on behalf of our client. And our client's claim is made stronger if the plaintiff can allege that the defendant should be held to a common carrier standard of liability. And that'll become relevant below when we consider damages. Now, personally, maybe it's because, again, my defense lawyer bias is showing, but I would suggest that the common carrier standard would apply certainly to the airline, but shouldn't apply to an independent ticket agency. Next, we turn to breach. It's easy to establish a breach because the ticket had wrong information and the employee communicated that wrong information. Is there but-for causation? Answer, sure. If the clerk had got it right, the plaintiff would not have missed his flight. Is there legal causation or proximate cause? Again, the answer is yes, there is. Next, we turn to damages, and we see that the plaintiff has incurred two separate losses. First, the price of the ticket, and secondly, the lost lecture fee. Ultimately, with regard to the lost lecture fee, we will focus on that below with regard to damages. But certainly it appears that this plaintiff was justified in relying on the misrepresentation that was made to him. However, he failed to double-check, and he failed to look to see about the flight on the day of the flight, and I would suggest that that will reduce his ultimate recovery in a comparative fault jurisdiction, and it will deny him a recovery altogether in a contributory negligence jurisdiction. So the last detail that I would touch on is that there's no affirmative fraud present here. And that's important, again, as we turn to damages, because it will deny this plaintiff a punitive damages award. Next, we turn to the third call of the question: do the facts presented here give the plaintiff any other theories of liability? And the answer is yes, they do. And that other theory would be breach of contract. And the idea would be that the contract was between Professor and Flywright. It was for the purchase and sale of a ticket on the airline. Flywright breached the agreement at the time it sold him the ticket because the ticket was wrong, and in fact, the plaintiff ended up missing his flight. So the plaintiff can establish a contract. There's no defenses to formation. The plaintiff can establish a breach by the defendant. The defendant really doesn't have a defense to breach, and that brings us to damages, which we consider with regard to the fourth call of the question. So clearly, this plaintiff has established a valid tort theory for negligent misrepresentation, and he's got a valid theory for breach of contract. So now we turn to the damages issue. And here what we're trying to do, again, under time constraints, is present as much analysis as we can and tie it to as much of the legal bottom lines as we know. So with regard to tort damages, we know that a tort plaintiff will likely seek compensatory and punitive damages. Punitive damages are off the table here because there's no deliberate act on the part of the defendant. There's no intentional tort being litigated. So with regard to compensatory damages, certainly the plaintiff would be entitled to recover the price of his ticket. Whether or not he would be able to obtain the value of his lecture is a much more open question, and I think that one could make a fairly persuasive argument either way, but ultimately I would think that the defense probably has a slightly stronger argument because the lost lecture fee really wasn't foreseeable to the defendant. If it was foreseeable, they'd certainly be on the hook for it. And again, if they are considered like a common carrier, with a higher standard of care associated with the travel industry, the higher their duty of care, the more foreseeable it would be that the plaintiff would suffer these losses. Ultimately, I would conclude that the tort theory of liability is somewhat problematic with regard to the lost lecture fee, but it is not necessarily an insurmountable problem for the plaintiff. I think one could make a conclusion really that goes either way with regard to the lost lecture fee. With regard to contract damages, again we see that punitive damages are really off the table. There's no deliberate fraud present here, so the plaintiff isn't going to be able to get punitive damages. Now, as we focus on compensatory damages, again, certainly the plaintiff is entitled to recover the value of his ticket. The consequential damages of the lost lecture fee are a lot more problematic, and I would suggest they are even more problematic in contracts than they would be in torts, because to recover damages in contract for consequential damages, the defendant has to be aware of the harm at the time the contract is formed. Now, this plaintiff did tell the defendant where he needed to go, but it isn't clear from the facts presented that he explained why that is. Now, again, based on my experiences as a paid speaker, I am delighted when someone wants to pay me to speak, and I'm always bragging to the travel agent about how lucky it is that I don't have to have a real job where I go to work at early in the morning every day earning money for someone else. But we don't find out about the small talk between the professor and the clerk at the ticket agency. If he does inform them during that conversation about the purpose of the trip, he might be able to recover in contracts the lost lecture fee. But based on what we know, it seems unlikely to me that those consequential damages really were foreseeable to Flywright. Again, if we want to impose the liability on Flywright, one of the technical ways we might do it would be tying them to the travel business a little more, and as a result of that intimate knowledge of the travel industry, we imply to them a greater degree of foreseeability than we might on some other defendant. So my conclusion ultimately is the professor gets to recover the lost ticket under either theory. But with regard to the lost lecture fee, his recovery in tort is somewhat more likely than his recovery in contracts. So we see, even though it's a straightforward, comparatively simple essay question, we've got to manage our time carefully, and we've really got to organize carefully to give us a chance to write a convincing answer under time constraints.